Thank you for joining us for another episode of Banter, which we're recording here in Dallas at the Old Parkland Conference. And our guest today is John Yoo, who will be doing a Starlight Chat this evening with Justice Clarence Thomas. So just a brief intro of John. He's a non-resident senior fellow with us at AEI, where he focuses on international law and the U.S. Constitution. He's also a law professor at the University of California, Berkeley, and a visiting fellow at Hoover. He's worked in all three branches of government, including as an official in the Department of Justice, where he worked on national security and terrorism issues after the September 11 attacks. He's also served as general counsel of the US Senate Judiciary Committee and has been a law clerk for Supreme Court Justice Clarence Thomas. As I mentioned, we're going to hear from him tonight, and U.S. Court of Appeals Judge Lawrence Silberman. His most recent book, Defender-in-Chief, Donald Trump's Fight for Presidential Power, was published in 2020. Thanks for joining us on Banter, John.
Thanks, Phoebe. And you didn't mention that next year is going to be my 20th anniversary at AEI.
Congratulations. That's very notable.
It's really great to have John with us for lots of reasons. There's a lot going on at the court. We can ask him about that. Of course, we have him here in Dallas for the Old Parkland Conference on issues concerning black upward mobility, and he's our sort of reliable interviewer of Justice Thomas. Mm-hmm. So he's done that before at AEI.
I'm the AEI Thomas Whisperer.
Well, it's going to be great tonight to have you question him, and I just give us a little sense of your history with him. You were a clerk, and what years were you a clerk? Was there a big case when you were a clerk with him?
Not only did I clerk for him when you clerk for a year, but several of the cases we worked on are ones that we've talked about at this conference, although people haven't, know them by name. So I clerked for him in the 1994 to 1995 Supreme Court term. And in that year, the court decided the case called Adirond, which banned the use of race in all federal government programs, federal government, contracting and welfare programs. We decided a case called Missouri versus Jenkins, which was a case about school desegregation, where Justice Thomas wrote a lengthy opinion. It's also a case, a court year where the court decided a case called Lopez, which placed for the first time since the New Deal limits on the reach of the Commerce Clause for Congress. So it was a really significant year. It was really, and Justice Thomas was, I think he was 45 years old at the time. And so it was great to clerk for someone who's so young, thinking things out for the first time, and you're kind of his sounding board, really.
And at this conference, as Phoebe knows, and you know because you've been here for the last day or so, is we've got a great collection of leaders from the African-American community, both community leaders and academics. They have I would say they tilt a little bit to the right of center. They're more likely to be conservative because that was one of the purposes of the conference. But what's been remarkable, to me at least, is the extent to which he's really a hero to this crowd, and how warmly he is received by people in the movement of helping African Americans move up in the United States.
It's interesting. I've had the opportunity to talk to a lot of the participants at this conference. And let me just say, this is, I think, one of the reasons why think tanks should exist. I can't imagine a conference like this being held at a university, because people are exploring every kind of idea from all angles. It's been wonderful. You're right. Justice Thomas is a hero, I think, in part because he's someone who has received all the arrows of criticism, and he's come through the other side with his beliefs intact. And so I think a lot of them, whether they agree or disagree with him, they admire his fortitude. But the other thing about watching Justice Thomas while he's been here is I've never seen him like this. He's like he's back in high school. He is so excited. I mean, he has been to every single minute of the programs. He's writing, taking notes. He's genuinely intellectually engaged with these issues, which are very near and dear to him, of course.
And so you've been watching this, and you know the writing of Glenn Lowry and Shelby Steele and Ian Rowe from AEI and Jason Riley. What are the themes that he hears in their voices that resonate with him, that you recognize because you've seen it over the years?
Yeah. And the interesting thing, I think the reason he's so excited is because these are things that are not part of the judicial role.
Yes.
These are things he's been thinking about before he was a judge. And in a way, my view is becoming a judge took him on a path where he can no longer participate in these kinds of policy issues. So Robert, this is your area. You're more the expert on this, the decline of the family. How do government programs hurt families or help them? That's a ringing bell, a clarion call, actually, to action. And I think he is so interested and engaged on that issue because, of course, they were talking about that in 1980 when they had the original Fairmont Conference, and he's still wonders what can be done. It's not the Supreme Court's not going to fix the decline of family, not just among blacks, but in America.
And also self-reliance or getting away from government dependency. That is
personal responsibility,
personal agency. Those are big themes for him.
Education, of course, the importance of education. I know really the people who've been most important in his life have been teachers. He talks often about the nuns he had the nuns who were his teachers when he was in school. His negative reaction, perhaps, to being at Holy Cross and Yale Law School. But then also encountering people after school who influenced him at intellectual level, obviously, most importantly, Thomas Sowell for him. But it just shows, he's on this intellectual journey. Being a Supreme Court, this is unusual. Being a Supreme Court justice, to me, is only one dimension of all the things he's interested in thinking about.
So we heard, Phoebe, in the conference, I would say, a lot along the themes of America has to get beyond race and move past, as Ian Rowe would say, viewing every problem of Black Americans as being about racial bias. I think Justice Thomas agrees with that. I can't remember this, but the classic line that the progressives like to mention from the current court is Chief Justice Roberts' line: "The way to stop discriminating on race is to stop discriminating on race." Does Justice Thomas does he identify with that position? Is that how you view his jurisprudence?
Yes. In fact, he was there before Chief Justice Roberts got there, I think. For example, in the term I clerked for him, there was this famous desegregation case that came out of Kansas City. And the first line of the opinion, he personally wrote it. I can attest to that. He said, "It never ceases to amaze me that just because something is black, it is assumed to be inferior." And he was talking about schools. He said, there's nothing wrong with having schools where most of the students are black. But in today's world, that's seen as wrong. He said, we should just care about their test scores and what they're learning and stop caring about the race of the students in the class. So he's been thinking this way for 30 years. So I think you're quite right, Robert, that is a theme of the conference. But at the same time, I don't think Justice Thomas would say race doesn't matter. It's just race doesn't matter in the eyes of the government. He would never say, race is part of who we are, is undeniably too.
Now I want to come back to that because I have some further discussions of that line of discussion. But we have to ask, given the period of time we're in right now, which is this odd period where a draft opinion has been leaked, and it's alleged that it has 5 votes, and it's written by Justice Alito, and it will overturn Roe v. Wade. In your conversations with him and your experience with him this weekend at this conference, do you sense any anxiety on his part? Is he upset by it? Is there what's your feel of his mood given this really quite startling controversy?
You're going to play this podcast after we do the interview tonight, right? Because you're ruining all my lines.
Okay.
It'll be after.
Okay, good. I don't want to give everything away, but
yes.
One thing you're seeing in the conference is very consistent with things he thought. If you go back and look at the original Fairmont Conference papers, which I tracked down, and actually is the first thing he ever published under his own name, is his little contribution. And if you go back, the theme there, the theme these days, and I think the theme with the court that bothers him so much, and I know this bothers you, Robert, is the attack on our institutions. Mm-hmm. The leaking of the opinion is an attack on the integrity of the courts, not just the Supreme Court, all the federal courts. I mean, I can only think maybe 1 or 2 times when any opinion at any level of federal court has ever been leaked this way. It's fundamental to the difference between law and politics. Politics is just, pressuring, lobbying, and voting. The law is persuasion, evidence, argument, right? It's not just about voting. It's not just about pressure. And so the leak is trying to turn the judiciary into just another version of politics. So that attack on an institution, I know, deeply, deeply bothers him and worries him, because that's the theme of that's the lesson I take away from this conference, actually, is that in all these areas from the 60s on, we've seen just this unending assault on the institutions that are the foundations of family, community, schools, and so on.
Mm-hmm. Can you speak a little bit to, just as someone that was a clerk and was entrusted with some of these materials, I think we all are so accustomed to leaks now that we're almost not as shocked as we should be that this is so unprecedented. Just from kind of behind the scenes of having been in that environment and trusted with some of those materials, how do you react to?
Oh, well, personally, I think this is also a great breach of trust between the justices and probably their clerks. Like 95% certain it's a clerk that leaked it if you look at the document and where it was in the process. And also, only the clerks would think you would care about the whole 90 pages of it, right? If you're just leaking in Washington, you would just leak the first 5 pages, because then that's the exexitive summary. Who leaks the whole report? Only a law geek would do that, right? Someone who's that?
I haven't heard that one yet.
Oh no, that's so obvious, right? Because and actually the first 5 pages are the most emotional. If you were going to read anything to really get a sense of Justice Alito's temper, you would read the first 5-6 pages. The rest of it is just sort of boring, clerk-driven, like standard prose. The first 6 pages, I'm sure Alito wrote by hand. It's so, it really is. It's a really internal. You look at the guy's mind. It has no citations, right? Like, it doesn't have all the attributes of, committee-written work. So I think it's a great loss of trust, because after this, think if this continues, how can the justices circulate drafts amongst themselves anymore? Would they become like the executive branch or the Congress, and every draft comes out in an important case is going to get leaked. Every vote's going to get leaked. Then the court could become like a legislature, right? They won't become this collective body that, even though they have differences, they still try to reason together. They try to persuade in good faith. That could all start to disappear. And then if you're the American people, you say, well, if they're just like politicians, why should we trust them to interpret the Constitution if they're just like the other branches?
Now, this Banter podcast will be released sometime next week. And what's the next step? What is your tick-tock on the time of the final vote by the justices and the release of the opinion? Could it be Monday morning? Could it be, or where are we in the court's calendar?
So part of the leak is not just the opinion. In a way, that's the most reliable thing, because you read that's clearly a Supreme Court opinion. It's really done at a very high level. Disagree or agree with it, the quality of it is very high.
Yes.
But there's other leaks attached to it, right? So you can't tell from the draft who voted for it. But according to the other leaks, there's 5 justices who are on board with overturning Roe and have not switched position. According to the leaks, Chief Justice Roberts really hasn't voted yet. He's trying to figure out a middle ground. And of course, according to the leaks, there's no dissent's been circulated yet. So all that's usually happening about now. So that February draft, it's interesting. It was leaked at a time when that would be the most extreme draft. After that draft, there's haggling, negotiation. It would almost certainly be watered down by now. And so I think the reason the timing of it is, the reason it's leaked in May, basically, is because there's only 2 months left now before all the opinions get released. Whoever leaked it realized if the votes haven't changed by early May, no one's probably going to be flipping their vote sans or without some kind of external pressure being brought to get someone to flip the vote, like Chief Justice Roberts allegedly did 10 years ago in the Obamacare case, when he, according to reliable press reports, I think, he changed his vote because of pressure that President Obama brought to bear. So the next thing that would happen is that these dissents, concurrences, separate writings all have a chance to circulate. So we normally wouldn't get an opinion for 7 more weeks. But if you're worried about pressure being brought and that someone might change their vote, and you're an institutionalist, you don't want that to be the way it's going to be in the future. You might try to rush the opinion out now.
Get it done.
Yeah.
And that's the last thing on this, and then we'll move on. But Justice Thomas did make news with a comment about what he was observing. And I think the quote was something along the lines of, we're getting to a point where people don't want to accept decisions they don't like, and they're refusing to comply with the rule of law. Is that what he said? Is that what he
Yes,
meant?
yeah,
And
that's what he
and
said.
just for our listeners, tell us what he meant by that. What is he saying?
Well, the questioner tonight will ask follow-ups on that, so that's not the only line that will come out of it.
We'll link to the full video.
But no, you don't have to do that. Make them
yeah.
make them pay a fee to access the AEI website before they get to see the video. Now, what he means by that is there are going to be people on both sides, pro-life, pro-choice. All they care about is winning on abortion. It doesn't matter how they get there. That is fundamentally not a rule of law approach, where what matters is not really who wins or loses, but the principle, and that principle then applies to everyone equally. The problem, I think, with the leak is that for him, for me, for people who believe in the rule of law, is it is sacrificing the independence of a judiciary that protects the rule of law just to win on abortion. So what's going to happen? I mean, think of all the things that are at risk. The Supreme Court's not just there to decide abortion cases. In fact, their more important role is to defend all of our individual rights when we're in the minority, to protect our Bill of Rights, to protect the rights of criminal suspects. That's all under, whoever leaked it said, that's not as important as winning on abortion. And that's a really political way of thinking at, not a rule of law way.
Mm-hmm. Well, it's a great pleasure and an honor to have Justice Thomas with us for this conference, and I know everybody here appreciates it. And of course, his own personal story feeds into a lot of what we've been discussing. So it's been really wonderful to have him. I'd like to turn for a minute to the other part of John Yoo.
So boring now.
Yeah, no. There's a part of you that's quite interesting, and that is. Banter is intended to flesh out the work of our great scholars. And so, John, maybe it's been told somewhere, but I haven't heard it been told. The book Phoebe mentioned is a book about presidential power and Donald Trump. Mm-hmm. And you could characterize it as a pro-Trump book. And then in the period of time between the election and January 6th, you were involved in the discussions with the vice president and helping him make the decision to abide by the vote of the Electoral College. And could you just tell our listeners about that? Or have you come clean on all of this?
Can I just tell the listeners that Robert is trying to get me subpoenaed by the January 6th committee? Because I actually have never told this story, but I will. And then I'm going to send you my lawyer's bill, Robert, which would be pro bono, because I'm going to represent myself. I've never. So it's very, my book was finished the summer of 2020, and it kind of went through all the constitutional controversies over Trump. And I tried to make the case that take away the tweets and what he was saying, what he was actually doing legally was pretty much in line with what past presidents had done, and that he was trying to actually protect himself with executive power, not use it in an aggressively affirmative way. So, for example, the Mueller investigation, he's using executive power to defend himself from investigation, and he never fired Mueller, which would have been within his presidential powers, I argued. So after the election, I consulted with people. People in the vice president's office reached out to me because I'd worked with them many years before. And I had written a paper at AEI about the Electoral College and how it worked and why, all the things the framers. And I had, written a little bit about what happens if the Electoral College fails, which a lot of people don't think or write about until, the last year or two. But I've been thinking about it for a long time just because I thought it was interesting. And so I went through with the vice president's office all the mechanisms that exist after the vote that people don't think about. They see the vote in November, they assume, oh, well, then it's just over. But there are all these intermediate steps that get you from there to certification by the vice president that Joe Biden's the winner. And so I walked him through the arguments for and against. I actually had probably more sympathy for the argument that the vice president has some kind of power, but the Constitution is silent. It doesn't actually tell you who decides if there's a dispute that an electoral vote is real. Like they not only did they not address it in the first Constitution, when they addressed it in the 12th Amendment, they still didn't address it. They just didn't do it. So I said, look, the most important thing, I said this to the vice president's office, is whether there's a real dispute over an electoral vote. Once there's a real dispute, then there's a system. But you can't let people just make up that there's a dispute. There has to be a court has to find something, or the case that's happened historically is the state legislature and the state governor send two different electoral votes to Washington, D.C. That's happened several times, actually, in our history. The most famous one, the 1876 election that resulted in the Compromise of 1877. So I said, this is what a real dispute is. And if President Trump's supporters just say, oh, we're going to appoint electors and we think it's a dispute, I'm going to say that's not enough. There has to be an institution, a court, a governor, a legislature that says there was fraud or there was a problem.
A finding by a body.
Yes. You can't just claim it because by your reelection committee. And I said, unless. And so after, I think about middle of November, after you start seeing all the votes come in and the electors starting to get appointed, I said, it's obvious there's no dispute. And that's what you should say. And then you don't even have to reach the harder constitutional question of who decides if there is a dispute. Yeah, so I don't know how I got quite outed because as an attorney, I was quite happy for that.
Have you been excommunicated? Have you been excommunicated by your
by the Trump people,
by a Trump friend, or you're keeping it from them so they?
No. Well, this is the interesting thing. So as attorney, and I treated the vice president's office as my client, I never said anything about this to anybody.
Okay.
And then on the day that Pence came out with his letter, with his opinion, saying I'm calling the election for Biden, I have no discretion. They said I had given them the advice for it. So they broke the attorney-client privilege on me. So they actually, it was the vice president's office told the New York Times that I had given them the advice along with Judge Mike Ludig about why they had to call the election for Biden.
We did a book event with Attorney General Barr last week in which he referenced those two opinions as being, prevailing and appropriately prevailing.
Tiny contribution compared to what he did.
Okay.
Because you remember Barr you covered this, right? The Barr's the one who definitively said there's no factual evidence of any fraud. And that should have settled it, actually. Yeah. He really did a great service to the Republic.
Now, last question about our conference. We had a pretty vibrant conversation about race preferences in admissions. Do you think there'll be a big reversal of the lower court decision in the Harvard, I think it's Harvard and North Carolina case? Or is the court only going to do one really big thing this year?
I figure after they take all the crap for Roe, everything else is going to be like patty cakes. But if you were to say what are the fundamental touchstone issues for progressives, the thing that explains their anger is that abortion is about identity. And affirmative action is also about identity. So I think if you're going to see similar heights of anger and pressure on the court, it might also come with next fall's affirmative action cases. The reason I think they're going to come out striking down Harvard and UNC Chapel Hill's policies is because in this issue, Chief Justice Roberts has always voted against racial preferences. You quoted his exact language in the K through 12 case where he said, I'm against racial preferences in K through 12 desegregation. He struck down part of the Voting Rights Act of 1965 a few years ago, which no one ever thought the court would do. So unlike abortion, I think his track record is very clear on racial preferences. And
the other five conservatives are not, is there any question about?
I don't think so. And unlike Roe, this is one where the great majority of the American people would agree with the court. This is like you can strike down these I think unconstitutional racial preferences, and the majority of the country will approve what you did. So there's no political risk really for the court the way it is with abortion. Mm-hmm. Yeah.
These are big, tough issues, and the court is a different court than it's been in the past, and it can finally take them on in a serious way. The other court issue that I want to mention to you, we did a conference not so long ago on the jurisprudence of Justice Alito.
Oh, yeah. Mm-hmm.
And Justice Alito was in the building for a dinner the night before, and he spoke with the scholars that were there, and it was lovely to have him there. And then the scholars and federal judges did a really great conference, and I recommend it to our listeners. You can probably find it on our website.
I bet the downloads went up about 2.5 weeks ago.
Yeah. So you're a constitutional law professor at the University of California, Berkeley. How is Justice Alito different from Justice Thomas?
So not to be harsh or critical, But I was interested in the conference AEI put on because the general account is that there is no sort of theme or clear jurisprudence by Justice Alito, that he's very conservative, and that on some issues, for example, on this Roe opinion, the Roe draft, the Dobbs draft, it's not actually that daring. It's like the summary actually of a lot of conservative criticism of Roe over 40 years. It's hard for me to say there's something in there that's Alito, right? It's Bork or Scalia would have written very much the same opinion. In fact, it's very much a Bork-Scalia opinion. Someone like a Justice Thomas or maybe Gorsuch who are interested in natural law, they might say, hey, maybe the fetus has a right to life under the Fourth, right? That you could see, that would be a really new direction. So I actually was always wondering, what is Justice Alito's jurisprudence that's different than sort of the Bork-Scalia sort of, we only enforce the written word of the Constitution, and it's mostly their jurisprudence. And of course, both of them were AEI scholars, which Bork, of course, for many years, and Scalia in between government. It's at AEI they developed this idea that the most important thing was to get the court out of the business of identifying unwritten constitutional rights because it was so damaging to
an exercise of raw judicial power, as Justice White said.
That's not where young conservatives are, right? So young of whom Gorsuch, Kavanaugh, and Amy Coney Barrett much more represent. They are actually much more interested in the idea of unwritten constitutional rights, but from a different source than Roe, the Roe kind of, but from more the natural law.
And well, you left Justice Thomas out. Where's Justice Thomas?
So he actually, I shouldn't have left it. I'm going to get in trouble with him again. He actually was the first one.
That's what I was going to say.
Yeah, he was like 30
ahead of them.
Yeah, he was ahead of them. In fact, you could say, and one thing you're seeing now at the court is all these things. When he was even a young justice, he would throw out these little ideas, like some of them were quite radical. As a clerk, I would wonder, why are you even writing this? This is not germane, or it's not really going to decide the case. No one's going to vote with you. But they all flowered into things. So to give you a great example, in that case that I mentioned, striking down racial preferences in government, Justice Thomas, I think, is the first justice in the history of Supreme
Did he
Court.
write the majority opinion?
No, he wrote just a concurrence.
Okay.
Yeah, not the majority opinion. But he wrote a separate opinion saying that the Declaration of Independence was part of our law and was the principle, all men are created equal, that stands against affirmative action. No justice had ever cited the Declaration of Independence as a legal document with authority in the Supreme Court because it's pre-Constitution. So to cite that means you think there are certain
something
basic
else,
universal principles.
It's also not part of the law. It's a different thing.
Yeah, exactly. So how do you distinguish
Lincoln
that?
used to always cite the Declaration.
It's very Lincolnian, actually. So that's an inspiration. But that was almost 30 years ago, and now you're starting to see fruition.
The way I interpret that, Phoebe, is that this is the
this guy's not a lawyer, but his dad was one of the great lawyers in the last century.
No, but the way I interpret
he sounds like a lawyer to me.
This is the super intellectual, cool kids around Justice Thomas and Justice Gorsuch,
AKA just the AEI lunchroom table talk.
And sort of poo-pooing the sort of bread and butter lawyer's lawyer, Justice Alito, who was always looking for, what's the term, reliance? He's worried about reliance.
Reliance interests.
And I think you should be nicer to Justice Alito.
No. That's what I mean. I don't mean to be harsh. I mean, in a way you could say he's a lawyer not driven by theory. He's taking the cases as they come. He considers all the factors. As you say, it's very lawyerly. But then you're trying to say, what's the jurisprudence implies? There's some great theory.
Oh, I see.
Yeah,
and there is no fancy jurisprudence.
I haven't found one in his cases.
Yeah,
I've read it. All his cases, but he's this Dobbs opinion is really if you want Roe to be struck down, it's probably the best thing that any judge has ever written in favor of overruling Roe.
And just go ahead, Phoebe.
Is at stake you mentioned that we don't really, Roberts is still kind of invisible in this opinion, depending on whether he comes down with the conservatives or concurs in a milder fashion or signs on with liberals. What does that kind of say about his oversight of the court? It seems to most people like he's kind of tried to steer away from some of the more controversial issues that now the majority has taken him into.
Well, it goes to the last discussion between the difference between maybe the Bork Scalia years, and maybe Alito still represents that, and then the younger conservatives. So I think the younger conservatives very much dislike the idea of a judge, hemming and hawing because of political pressure or the consequences of a decision.
The voice of the people.
Yeah,
what do you mean political pressure? The democracy still stands. I mean, elected officials do have a role. Congress exists.
Well, this is the interesting thing, right? This is throwing this all back to them.
Yes.
Right? That's part
What's the matter?
But I'm saying the younger ones, they almost see that as bending. As
very troubling.
They like judicial fortitude. Yeah. It's in their own way. They also rely on judicial power. You're quite right, Robert, when you say when you make this draw judicial power. Sometimes the younger conservatives are just as guilty of that as the old liberals.
Right.
Yeah.
So just last on this of sort of court history. So Justice White is having a little bit of a resurgence. It's
really?
Justice White's language.
Really?
Raw judicial. Don't you think?
I guess.
If
Well,
you read the Alito opinion. He quotes Justice White 25 times.
Yes, I'm sorry. I wasn't thinking about Byron White. I was thinking like 19th century. But no, you're
Byron
quite right.
White.
Yeah.
And I was just going to ask you. You weren't on Justice Thomas and Justice White. Did they overlap?
Yes, they would have overlapped. So Justice Ginsburg took over Justice White's seat.
Okay. So were you there when Justice White was there? Or
he was a retired justice. I was there, I think, Justice Ginsburg's second year and Justice Breyer's first year. So that's how old I am, is that they are now all retiring or leaving.
Well, are you, but you don't, are you saying that, I mean, I'm getting a sense that there's some that are saying that Justice White at long last deserves his place in the sun. He was right on Roe, and now he's being vindicated. And others are saying, Justice White was kind of a pedestrian justice. What's your take on that?
So I had a lot of admiration for Justice White, but he would have been the guy who would have said, there's no jurisprudence. We're just lawyers, decide it. So he famously, I'm not sure, it's apocryphal, but he famously said, reasoning is for wimps. It was very much of White, because Justice White, right? He was a great running back, a tough guy, right? He was a pro football player.
He was a Heisman Trophy winner.
He was a pro football player while
leading
he was in
rusher
law
in the NFL 2 years in a row.
So he was served in the Navy in World War II. See, even around the court,
Rhodes Scholar.
Yeah.
So
he was a tough guy, and so he was famous for. And I think Justice Rehnquist had this view too: is the only thing you're doing by writing opinions that have any reasoning or length to them is that you're creating mischief in the lower courts. So keep it short and brief. So Justice White was, famously anti-Roe, but he never really issued a, lengthy explanation of why. He did, write a few.
Few quotable lines.
Yes, exactly.
Yeah. So, John, what are you working on now? Where are you going from here? This is fun to talk about the court and Justice Thomas, but what do you really want to say to our listeners about your upcoming work?
So the book I'm working on now, I'm going to call Hamilton's Victory. And it's going to be a book about Alexander Hamilton's constitutional thought, which no one's really written about. And I'm going to argue that despite all the, and I haven't watched the Broadway musical. I'm so upset they stole all my material. They stole all my material. I got to wait for it to die down so that I can write about it.
What are you, one of the only people?
You never saw it?
One or two people that have never. Do you know the songs even?
Not really.
Oh,
no. Yeah. But rap's not my thing. Unlike you, Robert.
No.
He doesn't.
But so my argument is going to be that. Actually, Hamilton won on all these major constitutional issues. We don't live in Jefferson's Republic, even though Jefferson has the monument, and where the country has a lot of Jeffersonian rhetoric. But if you look at the country we are today and why it was successful, it's because of Hamilton's constitutional theories, which get ignored because people are so interested in he's a man of action, his relationship with Washington and his actions as Treasury Secretary. But I think actually I'm going to argue the most important thing he did was his to write down his constitutional views. And we never would have had a Lincoln or an FDR without Hamilton first.
That'll be great. I can't wait. And what about non-delegation authority? Didn't you come out with a recent volume that is going to be the court's Bible as they take on that topic?
So Peter Walson and I, we put together this edited volume for AEI Press, just came out a few months ago. The non-delegation doctrine, it sounds boring, but it's not boring. It is how much power can Congress give to the agencies? Could Congress just say, just regulate the environment. We don't really want to know what you do. You just have all the power. Does the Constitution say there's a limit? So the court itself has been saying there's got to be a limit, but no one can figure out the right principle and test to apply. So we got 10. I think this is a great thing for AEI to do. We beat everyone else too, is to say, well, let's ask 10 leading scholars, what should the court's test be? Give them the option so they don't just sit there and say, we can't do this because we can't think of the best test. So I think actually, in fact, this is I'm hoping.
It's a great product. It's
I hope
one of the
I'm
great
hoping
things AEI has
Yeah,
done
exactly. It's like what
5
we
years.
should do. And I'm
That's
hoping we do
that's
more
what think
things.
tanks are for.
Yeah, exactly. An academic wouldn't really, wouldn't do this all, 10 chapters, 10 different tests, right? It needs a think tank's focus on what's important.
Phoebe, anything more for John on Justice Thomas, the conference, the court, Roe v. Wade?
What young people should do? Phoebe, you should go to law school.
Hamilton.
Not for me.
Oh, wise woman.
I've already gotten it all from here.
Exactly. I was going to say, you've already learned it all. You might as well just get the degree now.
No, but this has been great.
Well, John, it's great having you. Thank you very much for helping us develop a strong relationship with Justice Thomas. And we're looking forward to your interview tonight. And I'm sorry I got to sort of try to get out all the surprises in advance. But the real surprise will be, or the benefit will be, what Justice Thomas says in response to your questions.
Exactly.
And again, thanks, listeners, for listening in. John Yoo, thanks for being here. Phoebe, live from Dallas, it's Banter.
It's Friday night.
The 13th.
That's right. Thanks, everybody.